Teens have not been listening to the genital cutters. Why do we care? First, before I go, why do we care? I want to say a word to Sierra, Dane, and Cecil. They have an excellent representation by Peter, Samir, and Eric. They have put together a complaint that will be difficult for any court, in my estimation, to dismiss out of hand. That there is a progression of the whole abuse of children contained in that 72-page complaint like I have never seen in any other complaint. So, as a disclaimer on the next slide, you will see a penis, natural-born penis, about an hour old, same child, 10 days old, after a Plastibil procedure. So if you're squeamish about photos, turn away. This is why we care. The intact, we were talking about smegma yesterday, a number of conversations. I believe that that is smegma covering the intact child's body, not only the penis, but the body itself. On the right is the same penis, same individual, same baby after 10 days. Quite a difference. And I have had doctors, deposed doctors, who have been unable to admit that the circumcision scar is an injury. It was not an injury because the intended result came from the surgery. That was her position. That because the circumcision created a circumcised penis, there was no injury. That is the logic that was used. Now, I was given a topic to talk about state versus constitutionality, and I thought, what the hell do I know, Northern Minnesota, about state versus federal constitution? So I took liberties to narrow it down, because it's just such a broad topic. What do I know about that? I'll leave that to Lawrence Tribe and others that have written books and textbooks on that topic. So I hope to cover today that a baby is human. And the focus of my talk is that we should focus on the baby, not on the parents, not on medical doctors, not on anybody else, not on the religious beliefs. Focus on the baby. And this discussion that just happened the last hour or so is a reason that I think it is very wise that you did not include the religious aspect in this attack. So thank you very much for doing that. So I hope to cover the human. The human is a right of privacy, the genital autonomy, and the fairness in the judicial system, and cover a few tales from the trenches. Most of the sites I use in this presentation are Minnesota sites, but I presume that most of the other states and jurisdictions have similar laws, similar protections for children. The Minnesota legislature, in response to a bill that was trying to stop, or there was this notion that babies were born alive and then were being killed after an abortion. So the legislature passed a bill saying that a live-born baby boy is, quote, fully recognized as a human person under the law. That is the law in the state of Minnesota. At common law, a child born alive and with an existence independent of and separate from its mother were considered a human being. That's the common law in the state of Minnesota, which I think somebody else cited Blackstone, which I will get to in a moment. And we must focus on the rights of the child, not on the parent or religious desires. Bodily integrity, basic human rights are protected under the 5th and the 14th Amendments. The Fifth Amendment protects against the loss of life, liberty, or property without due process of law. But the Fifth Amendment only applies to federal court action. So if the federal court or federal entities deprive someone of life, liberty, or property without due process of law, the Fifth Amendment kicks in. If it is done by the states, before the 14th Amendment, there was no remedy, unless the state had a similar provision. The 14th Amendment of the Constitution incorporated those protections that we have in the Fifth Amendment to the states. So it included state action as well. The county sheriffs, the school districts, all the counties, the other entities of the state. If they deprived somebody of constitutional rights and deprived property without due process, before the 14th Amendment, that could not be remedied. Now the states have to follow the Fifth Amendment as well. And as lawyers, we take an oath to uphold the Constitution. And in the preamble to the Rules of Professional Responsibility, if you read them carefully, you'll find that it's a lawyer's duty and obligation to represent those people who are disadvantaged or cannot represent themselves, i.e., the one-day-old infant as a child needs representation, and he is deprived of that for the most part. Now, Blackstone, this is a quote from a Minnesota case, citing with approval Blackstone's statement that the right of personal security consists in a person's legal and uninterrupted enjoyment of his life, his limbs, his body, his health, and his reputation. Life is the immediate gift of God, a right inherent by nature in every individual, and it begins in contemplation of the law as soon as an infant is able to stir in the mother's womb. That is, I think that is basically what the quickening argument is. When the fetus quickens, that inserts the rights. What is the right of privacy in Minnesota? Minnesota has the Levine case, which is, I think, very good for any attack on genital mutilation. And the Levine case was a case involving involuntary administration of neuroleptic medications for patients of a mental institution. But the Levine case said, and the Supreme Court said, that the right of privacy begins with protecting the integrity of one's own body and includes the right not to have it altered or invaded without consent. When intrusive treatment is proposed, the professional judgment of medical personnel insufficiently protects this basic human right. That is a compelling statement by a court stating that the rights of an individual are to be held prominent. Now, this involves an adult that was subject to involuntary procedures. The second case that reaches the same conclusion dealt with fluoridation of water in greater Minnesota, where the court held that no right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others, unless by clear and unquestionable authority of law. And that's where we get into the discussion about parental rights, the parental patriae argument, and the rights of the child. The personal autonomy is a basic human right in Minnesota. And just as an aside, the only case that I know of worldwide that has analyzed this issue from the child's perspective is the Cologne, Germany case. There they got it right. They analyzed it from the child's perspective, not the parent or the religious doctrine perspective. So genital tissue is constitutionally protected. FGM litigation, I see I have FMG litigation there, but that my spell check didn't get that. The genital tissue is protected by law both on the federal side and on the state side. It's a felony imprisonment for over 1 year if found guilty. If a medical doctor even nicks or does anything to the labia or genital tissue of a female, he's subject to criminal penalties up to a felony, which is defined as being subject to imprisonment for more than 1 year. That's the definition of a felony in Minnesota, at least. It may also be the same in other states. And if you look at this, house pets, dogs, cats, other things, they are protected criminally from gratuitous genital alteration under the cruelty to animal statute. But yet, it does not apply to humans. So, the baby boy's right is to an uninterrupted right of bodily integrity. During the circumcision, we all know what happens. I don't need to know that. And it is right that many people have talked about this today, that it is still a wonder why we in 2025 need to be discussing why it is wrong and illegal to cut the genitals of a 1-day-old infant who does everything in his capacity to say no. They squirm, they they move their arms, their legs, they're kicking. And what does the medical establishment do? Velcro straps. Velcro straps and a circumstraint. And I've always thought it would be a good thought experiment to think about any one of us going to another world where we don't speak the language, we don't know the culture, we don't know anything about them, but we land on their planet, and one of the requirements is to set foot on the planet, like stepping the foot inside of Abraham's door in Genesis 17, that you have to have your genitals altered, your penis cut. And if, hypothetically, they strap an adult down, and you do everything you can to say, no, 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 don't do this, would it be a crime? Would it be criminal conduct? All of us would say, in America, that would be the definition of false imprisonment, assault in the first degree, depraved indifference, and a whole host of other crimes that would be in play. Not to mention criminal sexual conduct. And somebody yesterday mentioned that the first experience that these children have is to be cut. The first sexual experience is the traumatic severing of the foreskin. So I want to go over some lessons I learned in the practice of law. And the first case is the Fishbeck versus the state of North Dakota. And again, I want to say that this was in 1997. 1997, almost 30 years ago. I challenged the FGM the statute in the state of North Dakota at the request of Dwayne Voskule and Jody McLaughlin. They were early intactivists who approached me and persuaded me to take this case on a the constitutional equal protection basis. And I understand Dwayne just recently passed away, but Jody is living up in Washington. But the facts were basically that the dad wanted a circumcision, mom did not. This was right after the FGM statute was passed in the state of North Dakota. And it's a felony to cut any female genital tissue. And we pursued it on the basis of an under-inclusive statute. So the under-inclusive statute was because genital tissue is genital tissue, and if you're protecting females, there's no reason not to protect males from the same assault on their genital tissue. So the outcome was the case was dismissed at the trial court level without a hearing. Dismissed without a hearing based on standing. Standing is an arcane argument that is available to defendants, which they use when they can convince the courts to do it. The court observed that McLaughlin and Voskuil, their convictions were very sincere, but they had no personal stake in the outcome. And the mom, Mrs. Donna Fishbeck, they said the injury to her son, if it is an injury, is in the past. And therefore, since we were asking the statute to be declared unconstitutional, we were not asking for money damages, so they said, we cannot give you a remedy. And so there, they said, that's how they dismissed it. And I appealed it to the 8th Circuit Court of Appeals. They issued, I think, a 2-page opinion citing one case, and if I remember right, it was a case out of Wyoming, the Wildlife Association versus the Lujan. Yeah, that's the case, yeah. So the lesson I learned from that is that the Constitution takes a back seat to cultural or religious norms. Now I want to go back again and talk about the complaint that's been filed in Oregon. It's a much more comprehensive document than I did 30 years ago. You have all of the history of circumcision, all of that history in there, and I think it will be a difficult task for the court to dismiss it without addressing the substantive issues. Another study of unfairness in the courtroom is the Flatt versus Tamtac case, and I think some of you might have been there. Dan was there to observe the court proceedings. So the facts were that the boy was served by the MD. The nurse had mom, who was a lawyer, sign a consent. She claimed that the only risk that was described was the infection. And so she sued both the MD and the hospital. The hospital was dismissed on summary judgment because the hospital has no duty to obtain informed consent. That is a non-delegable duty on the doctor. The doctor has to be involved in that informed consent discussion. So the hospital was dismissed because it had no duty, and the jury was shielded from photos of an intact penis, surgical tools, circumstraints, videotape of the procedure, animation of the foreskin, even deprived Dr. Cole of the ability to use illustrations to show the jury what the function of the foreskin was. He was there trying to draw pictures freehand on a chalkboard. And this was, the trial court made these rulings. Finally, the verdict was no negligence at all. But let's look at the evidence that was omitted. You have the circumstraint. You have the child strapped to the circumstraint, before and after. You have the cutting. Then you have all the other tools of the trade, the Domco plan, the forceps, the tweezers, the cutting instruments. Those are the documents that were disallowed before the jury. And why? The court disallowed these visual evidence because it was too prejudicial. The prejudice outweighed the probative value, is the analysis she made. And so we'll get to the concurrence opinion in Flatt versus Cantac at the Supreme Court level in North Dakota stated that although the trial court is afforded wide discretion in deciding whether to admit or exclude evidence, I remain concerned that the cumulative effect of the trial court's decision limiting the plaintiff's evidence may have denied them a fair trial. Do you think? But I cannot say that my concern rises to a conviction that a new trial need be ordered. This is what we deal with in the judicial system. And fairness in the judicial system is not guaranteed. I should mention that the personal cost of bringing this action, there was a cost judgment assessed against the plaintiffs because they lost. And that cost judgment included expert witness fees for the defendants, deposition costs, travel costs to take depositions in California, one in San Diego, one in Sacramento, and one in Grand Forks, North Dakota. And so the cost judgment was in excess of $60,000 levied against that infant boy.
Whoa.
What? Yes,
wow.
That child, the judgment levied against them, but the parents, under the statute, are responsible for that judgment. I paid those expenses out of my own pocket. The personal cost of bringing these actions is not insignificant unless you have a client that has an unlimited checkbook. The next case I just want to briefly talk about is the MGL versus Zabazinski. And you'll notice that all of these cases have appellate court numbers on them because these are all appellate court decisions. And typically, when I take a case, I might settle with a doctor and push the other issue on the hospital to the appellate court. But in this case, the facts were that the nurse asked, "Are you going to circumcise him?" Yes. The parents did not know circumcision involved cutting. And I think somebody else said many people didn't know that they were circumcised, even as 18-year-olds. But the parents told me that they had no idea that it involved cutting skin. There was no signed informed consent chart. The hospital, and by policy, exempted the circumcision from signed informed consent requirements, and it was dismissed on summary judgment. Both the hospital and the medical doctor were dismissed on summary judgment. In this case, the expert witness, I believe it was either Dr. Van Houw or Dr. Cold, put an expert report together. Dr. Van Houw's credentials were attacked because he is a conscientious objector from doing circumcisions. He does not do circumcisions. And so the court said he is not qualified to give an opinion about the function of foreskin or the cutting of a foreskin. That is how wacky our court system can be, especially with this issue. The outcome was a dismissal, and I appealed it. There was no appeal. The Supreme Court declined review, and so we were stuck with that dismissal. And the lesson I learned there, courts view circumcision from an infant viewpoint. Legal procedure trumps substantive human rights. The next case is DNN versus Thielander. The child was born with a cystic lesion, on his trachea. They scheduled him for surgery to remove that lesion. And this nurse on the black surgical board wrote circumcision and gastrostomy.
Jeez.
And there was the MD failed to review the chart, which stated no consent for circumcision given. There was no circ marked in the chart. The outcome was that the jury trial was waived by their first attorney, who was a large Minneapolis PI attorney who had valued the case at $5,000. So they waived the jury trial right. And then the clients came to see me to see what could be done. We arbitrated the case in St. Paul, and the arbitrator awarded $40,000, denied punitive damages, and I believe that Brian Morris was the expert witness for the hospital and doctor in this case. In that examination, I got Brian Morris to admit that he did not circumcise his own son.
Wow.
So the legal profession really lacks precedent to value a foreskin. The next case I want to talk about is DNN versus Bereska. There was no informed discussion at all. The doctor comes in, are there any circumcisions to do? The nurse says yes. Doctor says, set him up. The doctor settled for a confidential amount. The defense used that Baer decision as an award as a maximum limit. The hospital was dismissed on summary judgment that the duty was non-delegable. That is, the duty to make sure that informed consent was given. The lesson I learned here is that we need to, when these cases are brought, focus on the duty of the hospital to have the proper procedures in place to ensure that doctors do the right thing. And that is one of the things. And the other thing is sue on common law, the duty to protect the patient from harm, and use the federal regulations to describe the duty. Just a few reflections from the trenches. I've described a number of cases. Each of them are individual tort claims against the doctor or a hospital. That's not a way to rapidly change culture. And so anytime you bring an individual case against an individual doctor, you may get money damages to that one individual. It doesn't change the culture unless you are bombarding the courts with multiple complaints in multiple jurisdictions at multiple times. And I would say that we have to use existing laws to protect children, and there are many laws that protect children that are in place already that apply squarely to the issue of criminal conduct by cutting genitalia. And we have to focus on the rights of the child who is being cut. Too often, medical doctors will say, well, the parents wanted it. The parents asked for it. The parents agreed to it. That is a tale that is told that has no absolute merit. But it is persuasive to judges because the child can't talk. The child can't tell the judge what his preference is. It is the parents. So we have to focus on the child's constitutional rights, not the parents' right or whatever they have, a feeling that they have a religious obligation to do it to their child. So finally, the future litigation, we need more clients and more lawyers willing to fight this fight because we can't, as a lawyer, I can't go out and find clients and have, you know, I'll pay you to be a client. That's frowned upon. It's called chaperty and maintenance, I think is what the terms are, where you're, you know, ginning up litigation. We need a case for controversy. It's a child that is injured. Ideally, the plaintiff would be like named if he's under 18 and he is represented by his parents. There you have a marked injury because he has suffered the assault, the cutting, the mutilation. He has suffered that and continues to suffer that. And I would say that, you know, we can all wait for a perfect case, but I think the strategy is best by bringing any case you have where you can make the arguments that genital cutting is wrong. Absolutely, that it is wrong. And if you can make that argument to a court, in Minnesota, there are 87 counties. That means there are 87 district courts and probably 200 judges in Minnesota. So if one of those 200 judges agreed with you, you would have a base to start on. Then it goes up to the appellate court and it winds its way up. So I think that the active campaign to target boys and parents and some groups and entities might pass it off as a college fund. But you have to be careful because those cost judgments, you have to be willing to absorb those, otherwise you're going to lose your clients. But, so I'm almost done, so that's my talk today, and thank you very much for listening.